Mr. O'Sullivan. None was made to my office. I don't know if you had conversations with somebody in IDEC, but in terms of actual referrals, those are the two documents.
So the minister's letter came first?
The minister's letter came first, yes.
And then Mr. Adams's affidavit came after?
His affidavit came after.
And you say you're not aware of Mr. O'Sullivan's referral?
That is correct, Chair.
All right, thank you.
And would the minister's letter have come in November as well?
That is correct.
Thank you, Commissioner.
Lastly, on those initial steps, I just want to understand if you treat the question of the mandate, that is whether what's complained about falls within your mandate, whether you treat that differently from if it's a referral that's coming to you, whether you treat it differently from whether the Section 27(1) jurisdictional facts have been satisfied. Do you treat the two as one and the same, or do you look at whether those jurisdictional facts have been satisfied as a different or additional step at all? I'm asking this because what you've told us thus far is that between you and Mr. Sissoko, what you look at is whether the mandate has been satisfied. And I would have thought that the mandate relates to whether the offenses fall within IDEC's mandate.
Correct, Chair.
And even though related, the jurisdictional facts would not would be separate. How do you treat the two?
We look at whether or not the Section 27 makes out a reasonable suspicion of an offense. Can we see on which or on what this is based, and other additional information? It relates to, does the statement make out offenses, and therefore do those offenses fall within the mandate?
Oh, I'm asking because, again, I hope I'm not sounding like I'm probing at this stage. I'm asking because you did not touch on that at all in the exercise, what you refer to as a practical exercise between you and Mr. Sissoko.
Understood.
All right.
Thank you, Commissioners. You may continue, Advocate.
I think I was at paragraph 23.
Yes,
Thank you.
Just finished 23.
Yes.
Thank you.
The referral was made by Mr. Fadil Mr. Adams in brackets. It was not treated any differently. It was supervised and overseen like any other. There were 4 dockets that were relevant to the referral. Following the common established process, I sent a letter to the SAPS Divisional Commissioner, Detectives, Lieutenant General Sentumule, requesting the dockets. Paragraph 24. Following upon receipt of the dockets, the information contained therein was analyzed. Thereafter, an investigation was undertaken. The investigation unearthed sufficient evidence to 1, conclude that there was reasonable and probable cause for the prosecution, and 2, formulation of the charges against Lieutenant General Khumalo and his co-accused. The charges are contained in the charge sheet to which I have already referred above. 25. I cannot not discuss the evidence. I cannot discuss the evidence. Apologies, the not is to.
So we delete the not.
Delete the not, yes.
After cannot.
My cannot not. It's either my cannot or it is not. Thank you, Commissioner. I cannot discuss the evidence that will be led when the trial of Lieutenant General Khumalo and his co-accused gets underway, or the merits of the criminal case against them. The sub judice rule precludes me from doing so. Be that as it may, I may indicate that there was a series of matters referred to IDAC in terms of the Section 27 by 1, Mr. Adams. When the whole picture is presented, they include the following. 25.1. The manipulation of recruitment processes and appointment of persons without suitable qualifications into senior strategic posts in the criminal intelligence unit. 25.2. The bypassing of vetting personnel, especially senior appointments. And at 25.3, the appointments of persons not suitably qualified and or experienced as a form of gratification for their collusion later in the looting of state funds, for example, the purchase of properties. 26. As I indicate somewhere towards the end of this affidavit, I intend to apply for leave to testify before this commission. If leave to do so is granted, I will get an opportunity to expand on the issues to which reference is made above. State capture is a type of systemic political corruption in which private interests significantly influence a state's decision-making processes to advantage and or benefit of certain individuals. 27. When one looks at all the cases referred to IDAC by Mr. Adams, they depict the capture of systems and processes for private interests by the head of CI and other senior managers. This too is an issue I intend to testify about should I be granted leave to. 28. The picture that has emerged is that the appointment and installation of certain persons in certain positions within the Crime Intelligence Unit, CIU, by Lt Gen Khumalo and his co-accused persons helped them strategically to access funding without following proper processes. This is because their token appointments would not stop them from their unlawful acts.
Sorry, you refer to persons in the plural. The picture that has emerged is that the appointment and installation of certain persons in certain positions, and it goes on. The only complaint I'm aware of, I may be mistaken, is the complaint about the appointment of Brigadier Mukwele. Are there any other appointments in respect of which there are complaints?
So the appointments are in terms of other persons that are not in that specific leg of investigation.
Also, there are other names besides Brigadier Mukwele?
Yes, but not in that specific leg, but arising out of the complaint by Mr. Adams.
Sorry, maybe you're missing the chair's question. Was there a referral to IDAC in respect of other people or other positions?
When we got the referral from Mr. Adams, and it was given to the prosecutors together with those dockets, they were able to identify that there are issues relating to vetting and appointments. The appointment of Brigadier Mukwele was one of them, but I think there is one other matter where the issue of an appointment is also part of the complaint, a part of the investigation that was dealt with.
You're still not answering, Advocate Johnson. Was there a referral to IDAC in respect of other positions other than Ms. Mukwele or Brigadier Mukwele?
Not out of this, no.
So to the extent that IDAC went and looked at other people who were quote-unquote strategically placed, it's IDAC that decided to do that. There was no referral saying there are people who are strategically placed within crime intelligence. Investigate how they were placed there.
Commissioner Khumalo, to explain perhaps as follows, I don't know whether I'm using it's not a complaint about an appointment, as in a new appointment. perhaps it is a complaint about the placement of a person in a position that arose out of the non-compliance with the vetting positions. So it's not, the only complaint about an actual appointment was the Mokwele, that the allegation is she should not have been appointed.
So then there is no complaint to IDEC about appointment and installation of certain persons, plural.
No, it is a person.
Person.
I correct myself, thank you.
And that person is Brigadier Mkwele.
That was the only one that I am aware of that was referred to as an appointment. Thank you.
Thank you. Please proceed.
I'm at paragraph 29. Yes, sorry.
According to me, that's where you are too.
Thank you. Paragraph 29. This is what IDEC, upon looking at all the matters holistically, established. However, if one looks at an individual case, this bigger and clearer picture does not emerge. When looked at holistically, the cases depict state capture, fraud, corruption, and defeating the ends of justice.
Advocate,
Sorry.
before you go to paragraph 30, perhaps in line with the correction you just made at paragraph 28, we need to revisit the conclusion of that paragraph. You state that this is because their token appointments would not stop them from their unlawful acts.
That this is because their token
Yes.
appointment would not stop.
So the token appointment is Ms. Brigadier Mkwele's appointment.
Yes, would not stop her
Unlawful acts.
from unlawful acts. Am I then reading correctly?
Yes, no, I
Advocate
thought that amendment is necessary in light of the change you had made from to the start of that paragraph, that you're not talking about appointment of
Persons.
certain persons, it's only one person, right?
So then that last line, Commissioners, of paragraph 28 would read, this is because the token appointment would not stop her from unlawful acts.
Thank you. Then on paragraph 29, the one you just read, this is what IDEC, upon looking at all the matters holistically established. Just for clarification, I don't know if 29 flows from 28, because you were speaking about persons in the plural, whether the matters referred to in 29 are matters in respect of the plural in 28, or whether these are matters arising from your investigations following the receipt of the Section 27 affidavit from Mr. Adams. Where do we land? And then it becomes particularly relevant after we have effected changes to 28.
Yes. The paragraph 28 is in the singular.
Yes.
IDEC then looked at all the matters arising out of that referral.
Okay.
And holistically established, as one indicates then in paragraph 29.
So it's all matters arising out of the referral.
Correct.
Okay, I'm with you. Thank you. Oh yeah, it's pointed out to me, and I did caution this would happen. You have a correction at paragraph 27, which we forgot about now.
At 27.
It corrects 30, that's why it was skipped.
But that's why
She's actually correcting paragraph 30, so there are two errors that need to be corrected.
So okay, the first error is that your correction itself is erroneous, in a sense that you say at paragraph 11 you wanted to correct paragraph 27 of the original statement, whereas in effect it's paragraph 30 of the original statement.
So the error had an error.
The error had an error, so to
And my
speak.
apologies about the error having had an error.
Okay.
Okay, so we
Which
will-
is then the next
The 30.
paragraph.
Yes.
Yes.
Correct. So I will read, Commissioners, with your permission, I will read paragraph 30 as is, because the correction is a numerical correction. Thank you. Paragraph 30 in the original affidavit, once the investigation was concluded, I was briefed by the team that had conducted the investigation on behalf of IDEC. IDEC then applied for warrants of arrest against all the accused. I then prepared a prosecution memorandum and submitted same to the Director of Public Prosecutions responsible for the North Gauteng Division of the High Court, that is the Office of the DPP, together with a draft charge sheet and a request for the enrollment of the matter. The correction comes in wherein this accords with section not 24.3, Commissioners, it is 24 subsection 2 of the NPA Act, and that is the correction we sought in the letter affidavit, paragraph 11.
Correction effected, duly effected.
Yeah.
I say the correction duly effected.
Thank you.
Thank you. You say this accords now with section 24 sub 2 of the NPA Act. It also serves two purposes. If you could just speak to the purposes that you address in subs 1 and 2 of paragraph 30.
Paragraph 30.1. The first is that the DPP is a measure for checks and balances. And 30.2. The second is so that the relevant Director of Public Prosecutions may grant permission for and or agree to the enrollment of the matter, unless satisfied on the information given to him or her that there is a reasonable and probable cause for the prosecution. The DPP will not place a matter on the roll of criminal cases.
Thank you. Before you go to 31,
Which Advocate Johnson will go to after the T adjournment.